Everybody, my name is TJ Scott, and I'm a Minnesota estate planning attorney practicing with the law office of Timothy J. Scott. I can be found online at tjslawoffice.com. Today, I want to talk about something that is really fundamental to estate planning with a revocable trust. But first, I want to take a step back. People often choose to do estate planning with a revocable trust for the purpose of avoiding probate. And just a reminder, probate is a court case that your estate has to go through if you died owning assets in your personal name, and that asset is not transferred by operation of law, by something like a beneficiary designation or joint ownership. So many of us are familiar with joint ownership. If you're married, you probably are a joint owner on your home with your spouse. You might be a joint owner on bank accounts or brokerage accounts with your spouse, so that if something happens to you, your spouse will immediately inherit that property as the joint owner. They probably already have complete access to it as the joint owner. We're also familiar with beneficiary designations. Things like retirement accounts and life insurance policies often include a beneficiary designation on them, so that after you pass away, they automatically pay out to a particular individual. However, if you're a married person and you jointly own your home or bank account, something like that, what happens after the survivor passes away? Or if you're a single person, what happens after you pass away and you don't have joint ownership on that house or on that bank account? Well, that's where probate comes in, and the court gets involved in either reading your will or applying what's called intestate succession statutes to what happens to your estate. And a revocable trust is a really great tool for avoiding that probate court case. But for the tool to work, it's really essential that the trust be fully funded. And funding goes back to what a revocable trust is. A revocable trust is an agreement between two parties. One party, called the settlor or grantor, gives some property to another party called the trustee. And the trustee agrees to hold the property for the settlor and administer or deal with the property in the way that the settlor has asked them to. And this is generally written down in a written document called a trust agreement that lays out exactly what's supposed to happen with the assets. What's great about a revocable trust is that when the settlor dies, the settlor is often the trustee as well. So the trustee dies, you can have a successor trustee named, and you can have successor beneficiaries, so that that successor trustee can step immediately into your shoes in dealing with the property that you put into your trust, and either distribute it out to the beneficiaries or continue to hold it in trust and distribute out parts over time, whatever the trust calls for. So how do we make sure that the trustee is holding everything? And that's really essential. If a settlor dies and he's given, the home has gone over to the trustee, but the bank accounts and the brokerage accounts are still held in that personal name, well, this property still has to go through probate. Oftentimes it will end up with the trustee through something called a pour-over will, but it doesn't avoid that probate case, which is so often the purpose of doing the planning in the first place. So it's really important that you take all of the assets that you have as settlor, and that you make sure that they are either with the trustee or that they're going to pay over to the trustee after you die. And the way to do that is different for every asset that you have. Every asset needs to be handled in a specific way. So titled property where the government tracks the title, things like real estate and vehicles, there's some type of work that you're going to have to do to make sure that title has transferred over to your trustee. For non-titled property, things like bank accounts, brokerage accounts, business interests in an LLC or a corporation, and for personal property, those are handled a little bit differently, and each has a little separate different treatment that you need to go through in order to make sure that it's funded over to your trustee. Then there are assets with beneficiary designations. Again, retirement accounts, life insurance policies, and annuities come to mind really readily as assets with beneficiary designations, and those will often pay into the trust after death, but again, by operation of law, by that beneficiary designation. So let's talk about each of these. Let's talk about titled property, where government tracks title, and a prime example of this is real estate. If you own your home in order to get that home over to the trust, you need to record some kind of deed with your county recorder, and that deed that you record with the county recorder reflects a change in ownership from you owning that property in your personal name to now your trustee is going to own that property. And oftentimes, again, with a revocable trust, you are serving as that trustee. So it has your name listed, but your name listed in a special role as trustee of your trust, and it generally includes the name of the trust as well. And that deed has to be recorded with the county. If it's a transfer on death deed, it's very important that it be recorded before death in particular, because that's when the transfer on death deed takes effect. Oftentimes these transfers are done with a quitclaim deed instead, just so that it takes effect during your life and goes into your trust during your lifetime. Other titled property, things like vehicles, can have their title transferred to the trust by filling out a change on the actual title card. And it's just like if you were to sell the vehicle or something like that, you fill out the information so that the title is going to reflect the change, that the trust is going to hold the asset instead of you holding it in your personal name. For non-titled property, bank accounts are a really big example, or often something that needs to be funded into the trust, and that might be missed if you aren't taking these steps to make sure that everything's funded into the trust. But with a bank account, you need to change the name on the account, and that often means going to the bank and signing new signature cards at the bank. Most major banks can handle transferring directly into a revocable trust account. Oftentimes you can keep the same account number, but it is bank specific how they're going to handle it. And that's because banks have different systems behind the scenes. Some banks treat trusts as a business account and not as an individual account, even though really a revocable trust is you're continuing to hold the asset in substantially the similar way. But because they treat it as a business account, they'll ask you to shut down your individual account and open up this business account. Your numbers will change. It can affect things like automatic payments and that kind of thing, which can be kind of a challenge. Credit unions can also push back a little bit. Sometimes they don't like opening trust accounts, and instead they'll suggest either a pay on death or a transfer on death arrangement. And a pay on death or a transfer on death arrangement, where it remains in your personal name during your lifetime, but after you die, it pays over into the name of the trust so that you can cash the check in an actual trust account that you open after you pass away, although you wouldn't be cashing the check, your successor trustee would. That's okay to have that kind of pay on death or transfer on death, but it's not as ideal as actually transferring ownership of the bank account. And the reason is, planning with a trust also allows you to plan for incapacity and plan for the immediate aftermath of death. So incapacity is if you're in a coma and you need your successor trustee to step into your shoes and write checks to pay for utilities and that kind of thing. It's going to be really difficult if all that you have are pay on death designations on your bank accounts for them to access that money. The same thing with the immediate aftermath after your death. In fact, in that case, if you executed a power of attorney with your estate planning attorney, that power of attorney is not going to be effective anymore after your death. And so that can be even more challenging, where all of a sudden your heirs and the people that you love, your family, need to come up with money to pay for things like funeral expenses and maybe expenses of your last illness if that's pressing as well. But it can be really difficult to access those funds that you would want your family to access and that you could provide access to if you change title to your bank account so that they can access that money immediately after you're gone. Brokerage accounts, or accounts that you have in a mutual fund or that you're trading in individual stocks, that kind of a thing, are very similar to bank accounts. Likely there's a form that the investment company or the person holding your investment is going to want you to submit in order to transfer ownership, and oftentimes it takes something like a notarization or a medallion stamp in order to transfer ownership. But again, that can be different. It's different depending on on who's holding that investment for you. Business interests. An LLC will often transfer by an assignment of membership interests, and a corporation will often transfer by filling out a stock transfer and making a stock transfer happen. But it's very important for business interests. I would never advise doing this on your own. If there are governance documents in place for that LLC, something like a member control agreement, or for the corporation, something like bylaws or whatever governance document might be in place, it can be very complicated sometimes how that transfer needs to happen. Oftentimes there are restrictions on transfer that are built in, and you might trigger one of those restrictions on transfer if you do the transfer in the wrong way and without the agreement of all of the parties that might be affected by it. So it's really important to review those governance documents and make sure that you're transferring that property in the right way. Personal property is another non-titled asset, and personal property transfers into the trust. Well, personal property, first of all, is things like furniture, clothing, jewelry, could be firearms. Lots of different things are personal property. But again, it's not titled property. It's not something that the government keeps a title on. And that can be put into the trust with something called an assignment of personal property or with a bill of sale. Oftentimes it will go in with a bill of sale. Assets with beneficiary designations, for example, a retirement account, will pay into the trust after you have passed away. And this has become really complicated with the Secure Act, but the trust can be the beneficiary if the trust has the necessary retirement plan provisions written into it that detail how it should be treated under the Secure Act to make sure that you keep everybody as eligible designated beneficiaries so that they're able to receive over 10 years or they're able to receive over their lifetime if they have a special need or something like that. Retirement accounts can also be written to go directly to the adult children. If you have adult children and you just want them to receive the money directly, and that would be your plan under your trust anyway, is for them to outright receive that money anyway, then oftentimes it makes sense to include them as beneficiary instead of having it go through the trust. A bad scenario is if a minor child is going to receive your retirement account and there are UTMA or custodial provisions that apply to the account. And if you have minor children and you're not planning to do a revocable trust, I really encourage you to look very closely at how you've made that beneficiary designation and see if there are UTMA, which stands for Uniform Transfer to Minors Act, or custodial provisions where you can name somebody to oversee that asset for the child so it's not paid out to the child until 18 or 21, and you don't have to have a conservatorship appointed over that child's money. Instead, it can just be overseen by that custodian that you name. But an even worse situation is if it's paid out to a minor child directly, and that's because you will need that conservatorship or some kind of protective agent action, and it's not an ideal situation for anybody because it's expensive. There's a lot of reporting that has to happen to the court, and it's just a not ideal situation for the child and for the people who then are subsequently trying to raise the child and access those funds to raise the child. Life insurance proceeds is another asset that passes by beneficiary designation, and you can often just name the trust as beneficiary. In fact, it's a really great way to fund the trust is to have life insurance proceeds going into it. And keep in mind, if you've already retitled a bank account in the name of the trust, the great news is that that check is going to be depositable directly into that bank account. It's already in the name of the trust, and the life insurance policy is paying to that trust name. Annuities, often you just want the trust as a beneficiary if there's some kind of survivor right in that annuity so that it's paying into the trust. So again, I hope that you picked up some good information about funding your trust. Again, my name is TJ Scott. I'm a Minnesota estate planning attorney with the law office of Timothy J. Scott. And again, I can be found online at tjslawoffice.com. Thanks.